Today's video covers situations involving probate and real estate during times of loss, grief, and transition after the death of the real estate property owner. And I'll finish up with some real estate ideas that completely avoid probate. When a person who owns a house or other real estate passes away, title or ownership of the real estate goes directly to the person's heirs. Or if the person had a last will and testament, ownership of the real estate goes directly to the devisees, the people who are named in the will to take the property. It sounds simple. Title vests immediately in the heirs if there is no will, or if there is a last will and testament, title passes to the devisees. But transferring real estate after a person's death can require some additional steps to protect your interests and keep things simple. If you are an heir or a devisee, even though the title passed to you immediately, there are still steps that we have to take if you want to keep the property or if you want to sell it to someone else. Why? We have to take the additional steps to prove to the rest of the world that the title did pass to you and you really are the owner of the property. What additional steps do we have to take? First, let's look at the situation where you are taking ownership of the property through a will. We have to file the will in probate court and petition to have it probated. Probate means to prove that the will is valid. When we prove the will, we also establish who the heirs are and the devisees, and get the court to approve the personal representative, who will have the authority to manage the estate. If the will gave the personal representative the power to sell real estate, the personal representative will have the authority to sign a purchase and sale agreement and a deed conveying the property to a buyer, or a deed of distribution which puts on record the devisees who took title to the real estate. If the will has not been probated, no one can transfer ownership of the property. A potential buyer cannot buy the property because no one can convey good title. A personal representative doesn't even have the authority to sign a real estate listing agreement or a purchase and sale agreement until the probate court has issued the decree allowing his or her appointment. It's important to have the probate prepared, filed, and approved promptly, so the timeline for selling real estate is not delayed. Now, second, let's look at the situation where there is no will and you are taking ownership of real estate as an heir. If there is no last will and testament, we need to file a petition in probate court to prove that you and the other heirs are who you say you are, and to have the court appoint a personal representative, who is a fiduciary, who will have the authority to manage the estate. The predicament of having no will is called intestate, meaning no last will and testament. Transferring real estate after death becomes more costly and time-consuming if there is no last will and testament. Another probate step may be required: license to sell real estate. In probate court, a license to sell is a court decree which gives the personal representative the authority to sell the property at the price that you agree on with the buyer. If there is a will, but the will does not authorize the personal representative to sell the property, a probate license to sell real estate may still be required. If you are settling an estate, call to schedule an educational meeting to review all of your options for transferring property. Disappointment and confusion can be prevented during times of loss, grief, and transition. I can provide you with certainty that your title is established and that your purchase and sale agreement is prepared to protect your interests. I can represent you in the closing on the property, where your buyer delivers the real estate sale proceeds to the estate for distribution to the beneficiaries or heirs. If you own real estate, a will can save your family from the extra probate steps. I make sure that power of sale for your personal representative to sell the real estate is included in your will. If you already have a will, check to see if the power of sale clause is in the document. Finally, A will substitute, like a living trust or life estate, can avoid probate and transfer real estate without the probate procedures that we've been talking about. With a living trust or life estate deed, title to the real estate passes directly to the beneficiaries of the trust or to the remainder persons named in the deed without any probate proceedings. Estate planning in advance can save your family from extra probate expenses and delays, and can even eliminate the need for probate. To get started, you can download the PDF Trust and Estate Planning Calculator. The calculator totals up your asset values and then recalculates your totals whenever you update. It's my gift to you with no obligation, in the interest of helping you get started with estate planning.